Good day, sir. This is the presentation of Group 5. The case study of our presentation is Juan de la Cruz was convicted for a commission of a crime punishable under RA 9165, otherwise known as Comprehensive Dangerous Drugs Act of 2002, and impose upon him a penalty of an indeterminate sentence of 4 years of imprisonment as minimum to 8 years as maximum. He appealed his case to Court of Appeals, which reduces the sentence to 3 years as minimum to 6 years as maximum. Before we start answering those questions, I will briefly share the purpose of RA 9165, which is the Comprehensive Dangerous Drugs Act of 2002. It is the policy of the state to safeguard the integrity of its territory and the well-being of its citizenry, particularly the youth, from the harmful effects of dangerous drugs on their physical and mental well-being, and to defend the same against acts or omission detrimental to their development and preservation.
RA 10707. RA 10707 is an act amending the PD number 968, otherwise known as Probation Law of 1976 as amended. When we say amendment, meron lamang silang babaguhin na certain sections, pero it doesn't mean na hindi na mag-i-exist yung isang batas. Therefore, kahit meron ng RA 10707, still nag-i-exist pa rin ang PD number 968. Meron lamang ilang pagbabago o amendment na nangyari. Ito sa amendment ng RA 10707 and Section 4 o Grant of Probation. No application for probation shall be entertained or granted if the defendant has perfected the appeal from the judgment of conviction, provided that when a judgment of conviction imposing a non-probationable penalty is appealed or reviewed and such judgment is modified through the imposition of a provisional penalty, the defendant shall be allowed to apply for probation based on the modified decision before such decision becomes final. The application for probation based on the modified decision shall be filed in the trial court where the judgment of conviction imposing a non-probationable penalty was rendered, or in the trial court where such case has since been raffled. In a case involving several defendants where some have taken further appeal, the other defendants may apply for probation by submitting a written application and attaching thereto a certified true copy of the judgment of conviction. Sinasabi dito na dati daw sa PD 968, kailangan mo lang mamili ng isa. It's either mag-a-appeal ka sa kaso mo o mag-a-apply ka for probation. Kasi kapag nag-apply ka ng probation, automatically hindi ka na pwede makapag-apply for appeal. At kapag naman nag-apply ka for appeal, hindi ka na makakapag-apply for probation. So, anong ginawa ni RA 10707? Sinasabi dito na appellants can now apply for probation and provided that when they appeal their penalty was reduced into lower penalty below 6 years. Still, ginawa ni RA 10707 na kapag pinili mo ang probation, hindi ka na makakapag-appeal. Pero ngayon, kapag inuna mo na ang appeal, pwede ka na din mag-apply for probation. For example, nag-apply ka ng appeal and 9 years ang yung penalty. Tapos, naging lower siya at naging 5 years yung penalty mo. Therefore, pwede ka na mag-apply for probation. So again, because of RA 10707, those persons who tried to appeal their cases and still bumababa yung penalty nila or yung kaso nila, pwede po sila mag-apply for probation. In short, mas binigyan ng RA 10707 ng chances yung mga taong nag-ask ng appeal. But still, stricto pa din sila na kapag inuna mo ang probation, hindi ka na makakapag-appeal.
Number 1. Is Juan de la Cruz qualified to apply for the privilege of the probation? Give the legal basis on your answer. As to Section 9 of the Presidential Decree number 968, also known as the Probation Law of the Philippines, The benefits of this decree shall not be extended to those sentenced to serve a maximum imprisonment of more than 6 years. Since Juan de la Cruz was sentenced with 4 years as minimum imprisonment to 8 years as maximum, he is not qualified to apply for the said law. But if his appeal will be approved by the Court of Appeals, which then reduces his sentence to 3 years maximum to 6 years as maximum, then he is qualified to apply for probation. In Section 8 of PD 968 is the criteria for placing an offender on probation. In determining whether an offender may be placed on probation, the court shall consider all information relative to the character, antecedents, environmental, and physical condition of the offender, and available institutional and community resources. Probation shall be denied if the court finds that the offender is in need of correctional treatment that can be provided most effectively by his commitment to an institution, or there is undue risk that during the period of probation, the offender will commit another crime, or probation will depreciate the seriousness of the offense committed. So far, Mr. De La Cruz is good to go. He is qualified. Thank you.
Number 2 question, if ever the violation of Juan de la Cruz was found committed under Republic Act 9165 is drug pushing, will your answer be changed? Justify your answer. My answer in number 2 is according to Section 24 of Republic Act of 9165, known as the Comprehensive Dangerous Drug Act of 2002, non-applicability of the probation law for drug traffickers and pushers. Any person convicted for drug trafficking or pushing under this act, regardless of the penalty imposed by the court, cannot avail of the privilege granted by the probation law or Presidential Decree number 968 as amended. He can't apply for the privilege of probation owing to the fact that he committed the crime of pushing of drugs that punishable under Republic Act 9165, known as the Comprehensive Dangerous Drug Act of 2002.
What if Juan de la Cruz is considered a first-timer minor offender under Republic Act 9165 and the decision of the Court Appeals is to sustain the penalty of 4 years to 8 years of imprisonment? What could be your answer regarding his qualification for probation privilege? As stated in Section 70 of Republic Act number 9165, known as the Comprehensive Dangerous Drug Act of 2002, probation or community service for a first-time minor offender in lieu of imprisonment. Upon promulgation of sentence, the court may, at its discretion, place the accused under probation, even if the sentence provided under this act is higher than the provided under existing law on probation or imposed community service in lieu of imprisonment. If so, Juan de la Cruz can be granted probation.
Question 4. If ever Juan de la Cruz was sentenced before the effectivity of RA 10707, is he qualified to the privilege of probation law? What are the implications of RA 1070 to Juan de la Cruz application for probation if ever it is still pending for court's decision? To answer the question, we shall refer to Republic Act 1070 or an act amending Presidential Decree 968, otherwise known as the Probation Law of 1976 as amended. Section 1 of RA 1070 states that Section 4 of Presidential Decree 968 as amended is hereby further amended to read as follows. Section 4, Grant of Probation. Subject to the provisions of this decree, the trial court may, after it shall have convicted the sentence of defendant for a probationable penalty and upon application by said defendant within the period for perfecting an appeal, suspend the execution of the sentence and place the defendant on probation for such period and upon such terms and conditions as it may deem best. No application for probation shall be entertained or granted if the defendant has perfected the appeal from the judgment of conviction.
The continuation of the answer of number 4, it is provided that when a judgment of conviction imposing an unprobational penalty is appealed or reviewed, and such judgment is modified through the imposition of probational penalty, the defendant shall be allowed to apply. Then, the application for probation based on the modified decision shall be filed in the trial court where the judgment of conviction imposing of non-probational penalty was rendered, or in a trial court where such case has since been re-raffled. So, Juan de la Cruz is not qualified for probation. Under the law, no probation shall be granted if the defendant has perfected an appeal from the judgment of conviction unless it imposes a probational penalty. Hence, if one was sentenced before the effectiveness of RA 10707, he can no longer avail of the probation.